Well, a very good morning, everyone, and welcome to this seminar in relation to GDPR. It is only a 4-hour seminar with no breaks whatsoever. We'll then have a 15-minute break, and then there's an examination. So don't worry about it. There's no pressure on at all. I am, of course, joking. GDPR is a fascinating subject, and it really is something which is very relevant to today's society. And therefore, I'm very grateful that Cumbria Tourism have put on this seminar, an opportunity to speak to you about this very important issue. I think it's fair to say that often lawyers like to frighten people into submission with their horror stories about what is going on in the world in relation to GDPR. And in many ways, I will be highlighting some of the great areas of concern, areas where clients can get it wrong and the ramifications of that. But at the same time, be providing you with practical tips, advice, and support to enable you to avoid those horror stories. I don't know if some of you saw very recently, but issues in relation to lack of cybersecurity, which obviously falls into GDPR, has hit the British Library, based in London and in Lincoln, and they're currently subject to ransomware demands of about £600,000. It's always also led to a great deal of dislocation for academics and those trying to conduct their PhDs, in that they haven't been able to get access to some of the literature that they need. And I was listening to an interview with a lecturer from Durham University who was basically suggesting that maybe we should go back to biro and bits of paper rather than all this technology. Of course, we do live in a technological world, and the changes that are taking place have to be met. And what we want to do this morning is highlight some of the emerging trends and developments to enable you to cope with that. I think it's also fair to say that we all got very, very excited about GDPR a couple of years ago, had our policies and procedures in place, our privacy notices, our cookie policies, a review of the documentation that we were holding. And then, as per usual, sometimes we fall into bad habits, or we fail to remember the basic premises and principles of GDPR, which has led actually to the Information Commissioner's Office, the ICO, which polices this particular area, to be particularly active over the last couple of years. So what we want to do is outline the areas of concern, outline some practical tips, and hopefully that will encourage you to review and to refresh your policies in relation to GDPR and the messages going out to your employees, workers, and those that you're sharing information to as well. And one of the top tips I would recommend is that you actually think about what training have you offered to your employees, workers, and third parties that you deal with in relation to GDPR, because one of the things the ICO will be looking at if they did conduct an investigation would be how regular was your training, when was it implemented, and what did you do to reinforce the message? So we'll look at the present situation where we're at. We've now left the European Union in many shapes or form. Can we plot our own course? Is it the case that the onerous bureaucratic duties that were coming out of Brussels were not fit for purpose, and now a UK government can actually perform the level of scrutiny that's needed, which would be a lot lower level? We'd also look at some of the challenges, and the particular challenges are issues in relation to remote working, but also those individuals that may be working for your organisations that come in on a casual basis, or alternatively on an as and when basis, or are with you for a period of 3 months, then disappear, and then come back for a period of 3 months or so. That's often very common. And also the emerging issue in relation to subject access requests, which again are becoming very common. Burnetts will have a whole welter of personal data on my good self, and I'm entitled under a subject access request to see that documentation and data. That, of course, might include some pleasant, but might include some unpleasant things as well. We don't know, but it certainly would include not only, I would say, my personal details in relation to my bank account, my emergency contact number, or anything like that, but all emails passing between parties where I might be named. So you need to be careful on how you are communicating about people in relation to email correspondence, the notes that you're keeping, because they can ultimately make a subject access request. We see this particularly being used where somebody might be facing discipline or grievance issues, and therefore we need to be very careful into how we're utilising and dealing with SARS, because there are very strict time limits in place for actually responding to those requests. We'll look at some future developments, some issues on the horizon that the Information Commissioner's Office are particularly interested in at the present time, and then some practical tips. So, the present situation is that there have been some minor amendments to GDPR. There was the merging of the GDPR regulation and the Data Protection Act 2018 to make the UK GDPR compliant. We've seen very little changes, though, following Brexit in relation to developments that were going to take place. We did at one stage see government ministers talking about the bonfire of regulations, and one of the areas where they were particularly keen to ignite that bonfire was in relation to GDPR, which they felt was an onerous duty on organisations and was too heavily emphasised on issues in relation to human rights. However, that has not been the case, and the amendments to GDPR since Brexit have been very minor. Indeed, the message coming out of the Information Commissioner's Office is that there won't be any significant changes going forward, either under the current government or any future government, whatever political complexion, shape or colour that may take place. But what we have seen is the growing empowerment of the Information Commissioner's Office. We've seen an ICO that is expanding in terms of the number of people that they have working for the ICO, and also importantly, they're very keen on enforcement. Now, enforcement issues are often headline cases, so you have seen companies being fined up to £1 million or so, given data breaches, particularly the larger organisations, the transnational corporations, etc. But enforcement can take a multiple layered approach. It's not just about financial fines and penalties. The situation is, so I'll use myself as an example, I made a request for information to Burnetts. Obviously, this is a fabricated example, but I made a request for information to Burnetts, and I only got some of the information, and that took 2 months to take place rather than the months that they were required. I then go and make a complaint to the Information Commissioner's Office. The Information Commissioner's Office appoint an investigatory officer to see what was going on. Now, the problem is that once the Information Commissioner's Office have got an interest in you, they've got an interest in you. And it may be that they then decide to go down various rabbit holes in looking at how Burnetts are dealing with issues in relation to GDPR. They can have site visits, for example, and I was acting for a school very recently in relation to an ICO investigation. And one of the things that they came up with, and it slightly staggered me, and then I realised the importance of it, that in relation to IT protection, policy, cybersecurity, etc., they were very complimentary on the policies and procedures that had been adopted. But on a staff room, which was on the second floor, it had been regularly left open, a window left open. Well, what's the point there? Well, the Information Commissioner's Office said, well, you know, somebody could get in through a window. I know it's second floor, but somebody could get through a window and get access to documents that had been left on a desk. So enforcement is not just about the financial penalties, it's about the ICO coming around and having a look and investigating or conducting a review of how you go about ensuring that data is safe. I know it might seem a small point to say clean desks policies are important, but clean desk policies are important because ultimately what could be left on a desk is the crown jewels. You may think these are just spurious examples, but let's look back in some cases very recently. And 3 that I'd just like to mention. First of all, a deputy chief constable of a force in England takes some personal sensitive data documents in the boot of his car. He's working at home of an evening. He's done it for years. He goes shopping at Tesco's. He comes back from Tesco's and his car's been broken into. And including the documents that were taken from the boot of his car were personal sensitive data in relation to criminal activities, etc. The second example is in relation to Cornwall County Council, who had a set of filing cabinets that they decided to clear out and get rid of, and they sold it on eBay. The person bought them on eBay for £15, and when they opened them up, there were 2,000 files containing information about children who had been sexually abused within the Cornwall area over a period of 15 years. The final example is that if you wanted to find out what the UK naval forces were doing about 2 years ago in relation to strategic developments vis-a-vis the Russian naval forces, well, if you were standing at a bus stop on a Sunday morning in Kent on a wet and windy day and turned round, you'd find a bag full of government top secrets in relation to what those naval exercises were. Simple mistakes, easy mistakes, common mistakes that can be made. But what are we doing to ensure that the data that we have and the data that we hold is actually safe and secure? And that goes broader than just documents as well. For example, I'm aware that a top lingerie organisation which sells their goods in Heathrow may be in the next couple of months or so conducting redundancies. They're not going to go through the standard redundancy procedure, but they're going to try and fast track it. The reason that I know that, and the names of some of the individuals who may lose their job, is that I was sitting on the 5:20 train from Newcastle to Durham the other month and was sitting in the carriage next to the HR officer of that lingerie organisation, who was basically telling the whole carriage of what was going on because she was on the phone. So issues in relation to data leakage, and not just in relation to that physical documentation, but data that we might be sharing in an open place. So they may sound like spurious examples, but they're real examples. And the central point that I want to make here is in relation to data, it is the crown jewels. That is personal sensitive data about an individual that we may be leaking in an inappropriate way. Will there be potential liberalisation going forward? I think not. I think that the legislation has settled down. I think the problem is that people are not thinking about enforcement. They're not thinking about review. They're not thinking about refreshing their policies and procedures, and they're not enforcing within the workplace. We've seen in relation to the UK that they've entered into a number of accreditation agreements now that we're out of the European Union with various economic and national blocs, including over in Southeast Asia and also with the EU. And the agreement with the EU is essentially to honour and abide what is already in place. But I think we'll see that going forward. That's a bigger, broader issue that may not be relevant to your organisation. But I think the present situation is at the moment that we have what we have on the statute books, and it's very unlikely that it will change for the negative. It may increase its level of responsibility, but certainly where we are going to see changes is in that increasing level of enforcement by the ICO as more people become aware of, number one, their data protection rights, and number two, that the ICO is keen to be seen to admonish those who are in breach. So what are the challenges? What are the challenges facing us as employers, and what are the challenges facing us in relation to corporate bodies and corporate governance? Well, first of all, the central point is that we have a new flexible type of workplace. Now, we know that flexible working was apparent pre-COVID. We're certainly aware that it was dominant during COVID, and now we're in that interim state of how it's going to look. I was reading an interesting piece by a Harvard economist the other day, and he was arguing that in relation to flexibility, flexible working, home working, hybrid working, etc., we're going to see what he called the Nike tip. So, you know, the Nike swoop on the side of the shoe. And what he said was that, you know, during COVID, we saw it at the top of that little, we saw the top of the swish, and then we've seen a bit of a dip. We've seen a little bit of dip as people are returning to the workplace. Companies are trying to get greater communication and, you know, have people back in a working base. But he believes over a period of time that swoosh will go up again towards home working and flexibility. And we see that because, you know, we've got a different emerging market now in relation to, it's not that traditional employer-employee relationship, but we're seeing more casual workers, we're seeing more workers who may be performing activities for a broad range of organisations, and we're seeing more flexible zero-hour contracts coming through as well. So there's greater flexibility in the relationship. The thing is, though, that in relation to that new flexible workforce, that new jungle that we're operating in, data protection remains the same. So the fact that I may work for 2 or 3 organisations means that in relation to the data that is held, that information might be held by 3 different organisations, but I will be entitled to access to that information of all 3 organisations. And what are you doing to ensure that personal sensitive information that I may have access to in relation to company 1 is not being shared or inappropriately shared with company 2 or company 3? That's a big issue for employers now. How is that information being protected? There's also the new challenge of engagement, how we communicate, how we manage it and monitor. If we've got people working at home, how do we communicate with them? How is that data being shared when we're communicating by email? Now, things that may be said in the office, offhand, maybe it's banter or maybe it's information being shared, that is not recorded in that format, that handwritten or typed format. So it places a lot more emphasis on email communications and sharing data. So how are we engaging in that process, and what are we doing at that stage to ensure that we're data protection compliant? There's also the use of social media as well. We use that more in how we communicate with our client base, how we communicate with each other. What are you doing to monitor that communication nexus to ensure that the data that's being shared or the personal sensitive information is actually being dealt with in an appropriate manner? And the final limb of what we see in relation to the changing world of work is in relation to responsibility, the new parameters of work. Obviously, we've got our responsibilities to our employees, our workers, our consultants, etc., who we may hold data on. But what responsibility do they have in relation to the company to abide by the policies and procedures? So they're the new challenges that we face. And the GDPR UK legislation must fit round all of those issues. They must fit round and meet that new emerging world of work that you're facing. And that's why a core policy is important in relation to data protection, but also other policies and procedures must fit in as well. Is your social media policy one that ensures compliance with GDPR? Yes or no? Is it the case that if an individual is in breach of GDPR provisions, is that listed as an issue in relation to potential disciplinary sanction against the individual? Does it link in with our equal opportunities policy as well? So you can see that the GDPR policy, although it's key and constant, that around that sort of the skin of the relationship, those other policies and procedures, how do they actually link in to your core policy in GDPR? And do they work together, or is there a mismatch there? And that's something that you need to review. There's also the increasing danger of cybercrime as well. I mentioned at the start the current issue in relation to the British Library, and this is becoming very, very important. And therefore, there's an importance of cybercrime insurance, but also training on these issues for members of staff so that they can identify emails that may be coming in from a secure or insecure source, to identify where there could be cybercrime issues. And that's important that you're looking at that and providing training to staff on those particular issues. So First of all, looking at that whole concept of flexibility in the place of work. What is the place of work? I live in Durham, and I will often work from my home in Durham, or alternatively a service business office in Durham. I work in Carlisle, I work out in Newcastle, sometimes I might work in a cafe. So what am I doing to ensure, what's Burnetts doing to ensure that actually my place of work, whatever it may be, is constantly supervised and supported by GDPR provisions? And there's massive issues regarding confidentiality on IT and papers. What if some papers I'm using in a cafe are overseen by somebody, or I inadvertently, need to go for a coffee or go to a refreshment break, and I leave papers on a desk? What are the issues there? How secure is that? And what's up with WhatsApp? What about information that I may be sharing on WhatsApp with my colleagues? Now, sometimes organizations will have a designated WhatsApp site for their employees to communicate. Nothing wrong with that. But but at some stage that then becomes infiltrated by some personal comments? So, for example, we have a WhatsApp group within the employment team, and I'm sharing information, right? Who's where, what, where, and when today? What work have you got on? That's fine. And then somebody introduced a funny little GIF about people working from home, and then somebody then starts saying, "Oh, David's always hassling us and causing us problems, and I'm rather sick of the way that he's bullying me, etc., etc." Now, I could then raise a number of issues in relation to that, and somebody might say David's always off sick as well. Now, it might be that David is always off sick, but the reasons as to why David's off sick is that actually he may have a disability for the purposes of the Equality Act 2010. Potentially personal sensitive information is being shared there about David that he may find offensive, or alternatively might be inappropriate. What do you do in that scenario? What does your policy say? Clearly, your policy should be saying that in relation to WhatsApp, everybody, or any social media, be it Facebook, TikTok, or whatever media you're using, that number one, the GDPR provisions are prevalent, that there should not be any discussion about personal sensitive information, etc. So you need to be thinking about your social media platforms, equipment and remote access. If somebody's working from home, how secure is that actual home place? What about travelling documents? I made that reference to the Deputy Chief Constable in relation to documents that had been held that was in his car that he'd done for years per chap, but unfortunately on one day, on that one occasion, they were stolen. What travelling documents do your members of staff have? What do they have at home? Yeah. Who puts out the bins at home? This may sound like a strong point, a small point, but I go back to my example of Cornwall. Now, obviously, they weren't putting the bins out, but somebody hadn't checked what documents were actually in that set of filing cabinets and where it was going. Do you provide for your members of staff who are working at home some type of supervision and support in relation to how they deal with confidential information that they might have in the home place? Now, I'm not suggesting that every member of staff is given a personal safe or anything like that, but I think a warning should go out to your members of staff that in relation to travelling documents, they are to be taken as very serious and kept in a safe and secure place. And if they are disposing of confidential information or documents that may include personal sensitive data in their home place, that at least that documentation is shredded, or alternatively is shredded, put in a bag and brought back into the office at the next suitable occasion, or you ensure that that documentation never leaves the office, or you ensure that all travelling documents are stamped, or that they have where they are, and that they will be disposed of, and that the employee confirms that they will dispose of them carefully. So you've got to make sure also that your contracts and policies have been amended to reflect the above. If it is the case that your policies and procedures were drafted maybe about 3-4 years ago, before this acceleration of home working, it may be that they're not fit for purpose and don't actually meet the needs of your organisation. Now, the Information Commissioner's Office is not going to be kind and friendly and say, oh, well, these type things happen, they're going to say you're a modern emerging business, you've got these new ways of practice and how you're sharing data, you're allowing employees to be using personal mobile phones in relation to sharing data, you're allowing people to work at home and have travelling documents. What are you doing to ensure that's all safe and protected? What have you done? What training have you rolled out? What documents have you told them to refer to? How have you enforced that? So when David's documents were pinched from these car test scores, what did you do about it? Yeah, they're all issues that the ICO would want to know about. So in relation to engagement with a new type of workforce, I call it the deliver rooster economy. Who's delivering the work for you? Is it an employee who you've got quite a bit of control over? Is it a worker where they may be performing tasks for a number of organisations? Is it a casual employee that you've got, or a consultant? Is there third party involvement? Is there some outsourcing or subcontracting taking place? So what does the contract say? What do your contracts say to your employees about data protection? What does they say to your workers? What do you say to your casual members of staff? It may be the case. For example, I use my son as an example. He was home from university over the summer period, and he gained a job at St Chad's College in Durham. He was doing weddings, serving on that type of stuff, running the bar. Often he would have contracts in relation to being entered into with the wedding party. There would be names, there would be details, there'd be confidential information in relation to the guest list, that type of stuff. What had that university, and I'm not naming it, but it's got a beautiful cathedral and it's about 14 miles from Newcastle, and I live there. What is that university doing to ensure that that casual employee is GDPR compliant? Now, they could say, well, he's only a young lad. The information that he has is not particularly sensitive. He's only going to be working with us for a 6 to 8 week period. That would be a very lax approach because he's still in receipt of personal sensitive data. He has that in his possession and control. He's walking around with it. So what do they do about it? That's a key issue. Put that into your own nexus of what you might be facing in relation to your workforce. If you've got consultants working for you, they might be working across the piece. They might be working for 2 or 3 organisations. What are you doing to ensure the protection of the information, personal sensitive data for your organisation is being kept safe and secure? Could it be left? Could it be open? Could it be abused by somebody? I'm not suggesting you are. The people that you work for are probably very, very trustworthy. But what are you doing? What does it say in your contractual agreement with that consultant regarding GDPR? What training have they been given? Even if it's just a half hour. Hey, this is a bullet point guide to GDPR. This is what you need to be thinking about. And this is what we expect from you as an organisation. So that also occurs if you're subcontracting any of your services as well. What is the subby doing with that personal sensitive data? If you've subcontracted out maybe some transport or delivery, is it the case that that subcontractor has a list of your customers' data on a sheet, which she or he leaves on the front or seat of his van every time he goes out and makes a delivery? How safe and secure is it? What have you said to the subcontractors in relation to how you're protecting data, what you're doing? Is it left in a safe place? Is it protected overnight? Can you confirm that? This may seem like minutiae, but this is where the leaks in the plumbing take place. And the problems, as we all know, when there's a leak in the plumbing is that it's not just a trickle, or the trickle goes on for a long time or suddenly explodes. Okay, so your contracts with a third party, has this been updated in relation to your negotiations on GDPR? Are they giving you that assurance in contractual terms as to what they're doing? And has it been reinforced or stress tested at various stages to make sure that you're compliant? Are you rolling out training and updates? When did you last do GDPR training for your members of staff, your workers and your casuals? Question yourself on that. Yeah, we do it on a regular basis at Burnetts just to remind people. They're put on online training courses and they've got to comply with that. Otherwise, they might escalate to the senior partner and the senior partner will send you an email saying, why haven't you done that GDPR training? What is your excuse for not doing it? Yeah. So then you've got a record of all members of staff that have done the GDPR training and are up to date. What do you do about disciplinary steps when it gets wrong? Do you just say, oh, don't worry about it? Do you give a final written warning? Do you dismiss? It depends on the gravity of the situation. And I'm certainly not saying that it would lead to dismissal for a breach of GDPR. I'm not saying that at all. But at the same time, you must be putting parameters in place on what is acceptable and what is unacceptable behaviour, and taking appropriate steps to ensure compliance, because there's no point. Lawyers can draft you a beautiful set of policies and procedures, rest assured, and charge you a lot of money for it. But culture trumps policy. Yeah, what are you doing to ensure that culture is in place? And by enforcing that culture, that includes potentially taking disciplinary steps against those that are falling short. So engagement. You need to be looking, what I would be doing, I'd be stepping back and saying, what are the common problems or hotspot areas that I'm facing within my business and potential leak points? So if it is the case that I've got a lot of casual workers and I haven't done a lot of training with them, and they do have personal sensitive data, or they're exposed to personal sensitive data, that's a common problem. What am I doing to identify that leak point? And how are you rectifying them? Yeah. Are there potentially consistent problems across the board? Is it a particular team or function within your business that is having the problems? Is it your marketing team? Is it your human resource team? Is it a particular branch that seems to be a little bit laissez-faire and lax about issues in relation to GDPR? If that is the case, then identify that. Yeah, because monitoring is a key area of concern. Look at it. What are they? Where is the compliance issues? Why has laxity developed in terms of ensuring standards referred to? Is it the case that you've got a line manager who is, number one, not aware of the issues and hasn't been through the training themselves? Number two, that they are lazy and therefore not acting in an appropriate way. Or number three, is it the case that they're too stressed and busy to perform that function of looking at GDPR angles? Yeah, and you need to be identifying that. So if it's the person, a particular team has a problem, let's use the employment team at Burnetts as an issue. If it is the case that I haven't been through the appropriate training, there's a liability on the company. You have failed to perform your duty in relation to assisting that line manager. Number two, if it's the fact that I'm too lazy, then there's performance issues in relation to that line manager, because they have a responsibility to ensure that the GDPR policy is being enforced. Or number three, if it's an issue that I'm too stressed and too busy, then what are you doing about my workload? Because GDPR isn't just some small hat that can be put on occasionally. It has to be lived. It's got to be breathed on a regular basis. So what are you doing to support that manager? What are you doing? Because you're now aware that there's a potential issue there. Yeah. So has refresher training been rolled out to staff on data protection? Has that been documented? The example I gave just a couple of minutes ago in relation to Burnetts is that it's activated if you haven't done that online training. That activates a prompt to the senior partner. That activates an email to me. That activates a time by which I've got to do it in 7 days. And when I've done it, it's activated. Ping. If I haven't done it, that's activated as well. So there's lines of command at each stage. So if the ICO did come in and say, well, what training have you offered to your members of staff? Then the senior partner can say, well, this is the document that shows the training, and these are the people that have been compliant and done the training, and 1 or 2 people didn't, so we put them on correctional measures, etc. Okay. Another area that you need to do in terms of engagement, if there is a leak, are the contact details of the DPO correct? Have they been updated? Has the DPO changed over the last couple of years? And still on your internal documents, it says David Gibson is your DPO, contact him on blah, blah, blah. David left 6 months ago. If you ring that number, you'll get a voicemail message. What use is that? Remember, the ICO need to be informed within 72 hours of the breach becoming known. If that happens at 5:30, 6 o'clock on a Friday night, that's irrelevant. So who's the DPO? Is the information correct? Ultimately, the ICO will be holding you to account. Yeah, and here's some examples here. The Information Commissioner's Office fined the Cabinet Office. One would hope that the government would know better, but they didn't. £500,000 for disclosing the postal addresses of the 2020 New Year Honours recipients online. Unfortunately, I missed out that year, so my address wasn't there. But the ICO found that the Cabinet Office had failed to put out the appropriate technical and organisational measures in place to prevent the unauthorised disclosure of people's information, and that was a clear breach. Yeah. Responsibility, TUPE transfers. I'll just mention this briefly because it may not be relevant in relation to your business, but where there's a TUPE transfer, what information are you disclosing about your employees? And have you authority to disclose that employees to a potential buyer? Where's your signed consent? Where's your reminder to your employees that their data, their personal sensitive data, David Gibson of blah blah address in Durham, telephone number, national insurance number, details of next of kin, emergency contact number, details of medical records. What authority have you got to disclose that to a potential buyer? Has that been checked off? Grievance details, disciplinary matters, when you're sharing investigation reports about a grievance or disciplinary matters, is it GDPR compliant? Did you warn somebody giving information in advance that their name could be referenced? Do you need to give that name in the investigation report? You might need to. Might be relevant, but it might not. What have you done to check that off? Personal email details, very, very careful on this one about where you send emails, who you send them to. Have you checked the emails going out? And the Information Commissioner's Office is urging organisations to revisit their email practices after a failure by HIV Scotland led to a £10,000 fine. And there was a breach here where an email to 105 people included patient advocates representing people living in Scotland with HIV. All the email addresses were visible to all of the recipients, and 65 of the addresses were identified people by name. There'd been a bulk email sent out, so personal data had been disclosed. And what happens if you send the wrong email to the wrong person? Oops, sorry, not good enough. Maybe later out, it may be confidential information. What do you do about that in that scenario? So you need to be careful in terms of bulk email sending out. That's particularly important in relation to marketing issues. Has it been refreshed? Have you got consent to send emails out to those particular individuals? But also on a more personal level, have you sent it to the wrong person with the wrong details? There's a potential breach there. So also issues in relation to cybersecurity and theft. I gave the example at the start about the British Library and the ransom attacks. You should have a policy in place in relation on how to deal with that given situation in terms of procedures that need to be adopted. We recommend what we call a COBRA style command chain. So if there is a cybersecurity threat, who would be the first port of call? Who would be responsible for decision making? Who would be responsible for informing the ICO? That would be your DPO, your data protection officer, obviously. How are you then going to communicate with your client or your customer? Dear David, we're sorry to inform you that the data that we have on you has been subject to a ransom attack, and therefore it may be that your passport details or your national insurance number or your place of address or the name of your family members has potentially been compromised. The big issue in relation to the issue involving the British Library is not only national insurance numbers, but passport numbers as well, which obviously can, cause a lot of opportunities for fraudulent activity to take place. These are very serious situations, and they're more common than you think. You may be thinking, well, I'm an organisation where that might not happen, or a small organisation. Rest assured, everybody is susceptible to cybersecurity attacks, and they are issues that obviously you need to have a policy and procedure in place and how you're going to deal with that, including notification of the police and notification to your insurers as well, because in relation to cybersecurity insurance, there are specific steps that need to be taken. There are specific legal issues that need to be immediately addressed. Cyber insurance firms usually instruct high profile law firms that specialise purely in data protection, and rightly so, to guide you through those steps that need to be taken. And obviously, you've got to inform the ICO as well, because these are serious issues. You've got to think about how you're going to communicate, as I've just referenced as well, with your customers and members of staff. And a lesson from Morrison's as well. Situation was, this is a few years ago now, but it's a very interesting example, was that Morrison's had an employee working at one of their central sites, and part-time he was running a health supplement business. Morrison's weren't aware of this, but what he would do, he would use Morrison's internal postal system and external postal system to post out his goods inappropriately, and he shouldn't have been doing it until one day one of his clients sent back the goods because they weren't up to standard, and sent them back to the Morrison's postal office. One of the bags burst open, and it was white powder. It was actually a supplement for a drink, but somebody thought it was cocaine or drugs or something, so they called the police in, and the police investigated and took samples and said, well, I think it's probably a sports aid drink or something like that. But obviously it came to light that this employee had been misusing the Morrison system. Now, Morrison's very kindly, in many ways, didn't dismiss him, but they did put him on a final written warning. But he became outraged by this. He thought it was appalling. And what he did, he managed to somehow get into Morrison's payroll information and got all the details of the employees at that site. I think there were about 300 or so, together with their national insurance numbers. And what he did, he contacted the local newspaper, which I think was the Bradford Gazette or Bradford Argos or whatever it may be, and said to the journalist, he said, oh, I've got some really good information. I've got the whole list of employees at Morrison's in Bradford together with their national insurance number. Why don't you, I can pass that information to you and you can show how terrible Morrison's are. The reporter very wisely said, oh, thank you very much. Can you give me a telephone number, which he gave. And the reporter put the telephone down and then picked up the phone and phoned the police and said there's been a theft of some data from Morrison's, and here's the telephone number of the person you need to speak to. So the person was arrested, etc., for that breach, clearly. But what happened on the back of that was that about 100 or 200 Morrison's employees then brought civil litigation against Morrison's for that data breach, for breach of confidentiality. Now, ultimately, Morrison's just about got off with it because the court said you did as much as you possibly can. But I give that as a salutary lesson to you, that you can be quite easily exposed to litigation from your employees for failure to protect their confidential information, not only through a breach of GDPR, but a breach of the trust and confidence between the employer and the employee that exists in not putting appropriate safe mechanisms in place. So I think that may seem like an extreme example because it was a large organisation like Morrison's, but those claims are alive and alert, and you need to be aware of that. So in relation to subject access requests, SARS, this really is a new growth area. As I gave an example at the outset of the seminar, I'm entitled to request information that's held on me by Burnetts, and it's a new growth area, and it's often a tactic used when I'm bringing a grievance, when an individual's bringing a grievance against an organisation. They want to know what's being said, and also when there's a discipline hearing. So if I'm facing disciplinary action, I want to know what's being said about me and has been recorded. Now, there's a 1 month turnaround for employers to deal with that. You can ask for an extension of time if the request is particularly onerous, but it must be done within a month period. Otherwise, the individual can make a complaint to the ICO. You can challenge it where it's onerous or vexatious. So the subject access request, which can be made orally as well as in writing, by the way. If it's onerous, i.e. I want all data held on me, from 1985 onwards, that might be onerous. Or if I'm being vexatious about it, I'm just having a fishing expedition, then that can be rebuffed, but you've got to have good reason for that. You don't have to disclose information that's legally professional privileged, i.e. if I've given advice to a client, that wouldn't be disclosable. It may be that you need to redact certain references to other people, but please note that it can cover any personnel records, emails, notes, social media communications about that individual. So if one head of department has said to another head of department that David Gibson is a right buffoon, I can't believe we're employing him, it's about time we got rid of him, let's try and get a reason, that would be fabricated. That would be information that could be disclosed about me. And rest assured, if I got sight of that, then my grievance would be escalated very, very quickly. It also includes any notes that may be made about me. So if a line manager is making notes in a notebook on a piece of paper and I'm named on that, then that should be disclosed as well. And that's particularly relevant where an individual maybe has been in a grievance or disciplinary hearing and seen me make a note, and can say, I want a copy of the note that David Gibson was making during the seminar on the 22nd of November 2023, and notes in existence because I saw him writing it. It's as simple as that. Often SARs are used as fishing expeditions as well, and you need to be careful that they're not just fishing expeditions or onerous or vexatious, but the general rule is that if the information's there, it should be disclosed. So in relation to some practical tips, policies and procedures, roll them out again. In your induction procedures, I'd really hammer home issues in relation to GDPR, so that at the outset of the relationship, even if it's casual members of staff, that they're aware of the importance of confidentiality. Have your contractual clauses in place in your contracts of employment to cover the requirements and discipline where need to. Check remote applications if people are using, their own personal mobiles for work calls or storing work information, etc. What's the security level in relation to that? Is it password protected? Do you have passwords that are regularly changed to ensure that they can't be hacking? I've got to be honest, I use one password for about 15 different accounts, which is terribly wrong of me. Teach thyself. But if one person could unlock one thing, then they're going to cascade into unlocking another 15. What are we doing about that? And multi-stage authentication devices are quite useful in relation to that. Cloud storage, what you're doing, the protection measures of any information you've got in the cloud, is it only key staff that are having full access? What communication are you doing with third parties? How are you ensuring in relation to their keeping the data safe that you're forwarding to them? Mystery shopper, why not get somebody to stress test your system now and again? That's quite useful. And be very, very careful of data graveyards. That's a big area that the ICO are particularly interested in at the moment, data graveyards. You've held information on your members of staff for 20 years or your customer base for 20 years. What have you done to clean that out? Now, it may be that you can justify why you've been holding that information, but you need to be able to justify it. So, for example, Northumbria Police hold records for 100 years, and they justify that because they're dealing with criminal cases and information may come to light which sheds light on issues that have gone on in the past, and therefore that information stored. They can justify it. Can you justify holding information for 100 years? I think not. And if you are holding it for lengthy periods of time, why? Because the Information Commissioners are interested in that. So next steps, what's happening in the future? I think the ICO are looking more at anonymising information and data to ensure that personal sensitive data can't leak and that it's less identifiable. Areas such as application forms. Do you keep the application forms? What are you asking for information on that application forms? How long do you keep them for? How secure are your application forms? Certainly data issues involving health. How secure is that personal sensitive data? This was a big issue during the main period of the COVID pandemic, obviously, because people were keeping records on who'd had a vaccination, maybe who'd had COVID, how regularly had COVID, etc. And I think that will remain so. And that also interlinks with issues in relation to equality legislation, in relation to those who may have a disability. What are you doing to ensure that their personal sensitive information is kept sensitive? Personal sensitive data in relation to transgender issues. If somebody is going through through gender reassignment, what you're doing to ensure that that data is safe as well. That's a very personal, sensitive issue. And I think that's coming more to the fore about what information you are holding and how you're identifying that particular individual. They may want to be identified as a female. Do your records still identify them as a male? Yeah, think about that. And SARS, I think this is only likely to become an even bigger issue as more people become aware their entitlement to data. So I think SARS requests will increase exponentially over the next few years, and particularly in relation to grievance disciplinary, but also dismissal as well. People making applications to have that information to assist them in bringing any employment tribunal claims. So the last slide on the seminar before we can move to some questions, if anybody's got any questions. I think it's fair to say that the old is dying and the new has arrived. We have a new world of work out there and a new host of relationships with our customers and our client bases, etc. And it's imperative that you are compliant with GDPR to ensure that there are no link points. I think training is key. I really do. Even if it is a half-hour training update for your key members of staff and all members of staff, even those casual workers, so that they're aware of it and you document that. David Gibson attended the seminar on the 22nd of November 2023. He signed off that he'd understood, read, accepted the policies and raised any questions that were needed. Identify those hotspots. If you've got a weakness, particular manager, particular branch, particular sector that you find that there's issues, identify those hotspots. Indemnity protection with third parties. So if they do leak your data or if they do make a hash of it, what indemnity protection are you going to get from them in the event that the ICO tries to come looking for you for a fine or levy or penalty? I think home working policy is key. If you've got home workers, I think you must be making sure that those home workers are GDPR compliant. Again, I go back to my central point. It's not the case that all members of staff are going to have a safe in their office, etc. But at the same time, I think you need to be thinking about what data they may have at home and how that's operating and how you're monitoring that as well, checking in to make sure it's working. I think it's about accountability of staff as well. I think you need to be saying to your staff and your workforce, look, this is a two-way street. It's not all about our responsibilities to you, which are obvious, but it's about your responsibilities to us to make sure that you are compliant. We've given you the training, we've given you the support, we've given you the monitoring. You've got to ensure that you're acting in accordance with those policies. Nothing's foolproof. Nothing's ultra safe, nothing's bulletproof. But at the same time, if you put some of those recommendations into place within your organisation, you will certainly be ensuring that you have protective measures in place. And of course, you're protecting that important data, which essentially are the crown jewels of any organisation. That's all I've got to say on the issue. I've gone on a little bit longer than I anticipated. I do apologise for that, but if any further information is required at any stage, you're more than happy to contact me. I'll do Q&As very shortly, but my details there, Burnetts and my mobile number, which I'm happy to share. It is personal sensitive data, but I'm happy to share, so I've given that authority. If you need to text me or call me, I'll be delighted to do so. That's a picture which one of my members of staff thought was the most appropriate for me. That it's always a scratching head moment when you're talking about GDPR. It is a difficult area. It's an ongoing area. It's a live issue. And I hope during the course of this morning you realise that, yeah, it is a bit heavy, but it's not dull. It's not tedious. It's a living, breathing, functioning, important part of our society, and getting that balance right and getting the protective measures in key is crucial to ensure that the spirit and the intention of the legislation is adhered to.